Hello and welcome to the key point video for tutorial 4 on W201. We looked at a number of issues and we spent most of the time looking at judicial review. And I will say a few words about that in a minute, but I did spend some time at the beginning of the session looking at some of the things that you can do to improve marks for TMAs and also of course for the examination. And of course the one, and it should be obvious but isn't, is that faced with a question you need to answer that question, not the question that you would have preferred to be put. And I confess to the group that I have a dark secret. I have in the past, and probably still at present, could describe myself as a politician. And as politicians, we were trained not to answer questions. Of course, it wasn't put in that form. It was all about media training and making the point that if we had something to say, we had our agenda, and the journalists may have their agenda. And we should make sure that we weren't diverted from getting our message across by purely reacting to what the journalist was saying. Well, I'm not sure that that does politicians any good, or that it's done the press any good. Particularly when you see the sort of standoff that we've seen on Jeremy Paxman, where a politician repeatedly refuses to answer the question and makes himself look a fool, and Paxman, or whoever the other interviewer is, keeps asking the same old question until we're all tired of it. I'm not sure, but I am certain that if you substitute something else for the question that you answered, you will pay for it. So make sure that you are answering the question that is set. The second is that, and again to my group, I've sent out an email about the different levels of skill involved in answering a question. And at the first level, there is description, and a good description will get you a good pass, but that's about it. To improve your marks, you need to shift the balance away from describing cases, describing the law, and moving on to explaining, and then discussing, and analysing, and critical evaluation of some of the claims, of some of the laws that you're being asked to discuss. So think when you're preparing your essays, is this just description or am I going further? Because you need to go to those further steps to get marks, particularly now with the competition that there is within the legal profession and elsewhere, where higher level degrees are wanted. One of the things that will help you do that is, and I'm not suggesting that you read the law report for every case that gets mentioned, because if you do, you will go mad. But read on a regular basis relevant cases in full, not just in the casebook, not just in the manual, but look at the reasoning that the judges are putting forward when they come to their decision. Because that's the kind of legal reasoning that is required of lawyers. As I say, it doesn't come easy. Some judges are much easier to read than others, and I made the contrast between Lord Denning, who, to be honest, is a joy to read. He has a wonderful style. He starts cases with phrases like, "Mr. So-and-so was a nice old man." Well, you won't find that in the judgments of Lord Gough. But, again, he makes important points, but you need to work harder to unravel what he's saying, because they are, frankly, quite complex areas. But the more you read for cases, the easier it becomes. The more you get used to extracting the relevant facts and particularly that legal reasoning, because when you've seen the legal reasoning, then you can do the critical evaluation. Just taking it from the manual or a textbook really doesn't give you sufficient information, and you haven't developed sufficient knowledge from that brief read to be able to give the matter the attention that would be required for the higher marks. And another important point for W201, but it's relevant for any law studies, do not confuse the European Union with the European Convention on Human Rights. Two very different organisations. Now, of course, there are links between them, but the EU has 27 members, the ECHR is part of the Council of Europe, which has 47 members. The European Court of Human Rights is in Strasbourg. The Court of Justice of the European Union is in Luxembourg. It's the European Communities Act of 1972, which brings EU law, as it has become, into British law, whereas the Human Rights Act of 1998 allows British courts to apply directly the European Convention on Human Rights. If you are not entirely clear about the distinctions, drop me an email at jdavidmorgan@googlemail.com and I'll be happy to send you a handout that lists the two. But very important point, because if, particularly at the end of 201, which is the second unit in a law degree, to be seen confusing the two can be regarded as a fundamental flaw which can cause a question that you've answered to get a fail mark. So very important that you do that. On to the next TMA, it's about judicial review. Judicial review can look horribly confusing. There is lots of detail and it's a very profitable area to go in as a lawyer. But for the purposes of your study, concentrate on the key elements in answering a judicial review question. And these are, when looking at the facts of a problem, first of all, does the body whose decision you wish to complain about, or the person in your scenario wishes to complain about, does that decision-making body have susceptibility to judicial review? Is it a public body? Is it carrying out a public function? Again, there are some cases beyond that, but it's the first thing you need to consider. If it is susceptible to judicial review, is the person bringing the review, do they have standing? They need to be personally involved. It can't just be do-gooders going around sorting out all the wrongs. There are circumstances in which an interest group may be regarded as having standing, but that's the second issue. Third issue is the question of the time limits. There's also often a question of, is there an ouster clause in the original legislation, a clause which says that no court shall question a decision made under the power that's been given. Again, look at how the courts have dealt with ouster clauses. Then you need the grounds for judicial review. Make sure that you are very familiar with the Diplock classification of procedural impropriety, of irrationality and illegality, and of course subsequently we have the Human Rights Act and the breach of a convention right. But below those main headings you'll see certain phrases coming up a lot, labels almost, like the rule against bias, the right to a fair hearing, and so on. As you read through, have a look at those phrases, and again, if you're reading cases, when you look at judicial review cases, you will see these labels being used. Make sure you're familiar with them. And of course, having decided which grounds, and in most cases it's not just a single ground, it may be a number. There is the issue of remedies. If you work through in that logical manner, you'll find this TMA fairly straightforward, and you'll find that you have an ideal model for answering any question in a subsequent exam. Well, thank you, and I look forward to our next little chat about tutorial matters.